Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property.
Hello, Stu. We're on to Conveyancing Matters News Spring 2025 already. Can you believe it?
We certainly are. The year is absolutely racing away already, isn't it?
Isn't it just? And of course, it's racing by for conveyancers due to, the at least the ending of the stamp duty land tax no holiday on the 31st of March due. Pretty grim and pretty difficult for all of you live conveyancers out there, really.
Yeah, absolutely. It's been a tough few days with the volume of completions that have gone through, a tough few weeks and a tough few months. So thank goodness it's all over.
Yeah, and with that in mind, Stu, we thought, didn't we, that actually it would be really nice to give conveyancers the chance to sort of come to London, have a drink with us on the 15th of May
Yeah.
at the Wood in Shades in near Liverpool Street. So we'll put out more information, but we would like people to save the date, wouldn't we?
Yeah, absolutely. Yeah, we just thought we'd sort of meet up in an informal atmosphere, have a few drinks, and kind of celebrate the period that we've gone through. Because I'm sure for most people, it's going to be one of the toughest sort of times in their career.
Yeah, absolutely. And but the lovely today's media group, led by the rather gorgeous David Opie, who's going to be joining us for a chat soon. Of course, they did hold the British Conveyancing Awards, which was a fantastic event. I was a judge. That was very kind of them to ask me. But Stu, I know you would be too modest to say otherwise, but this is legitimate news. So congratulations, because PCS, I think PCS snuck a little award there, Stu. So tell me about that.
Yeah, we sneaked in there and managed to win the innovation sort of category. So yeah, that was absolutely great. It was a really good evening. Congratulations to sort of everybody that won on the night. Vernon Kay was sort of comparing. So yeah, it was a really good evening.
Oh, excellent. So what was your innovation product, Stu?
It was an onboarding platform that we developed for our clients. We've used off-the-shelf products before, but we just thought we could do something a bit better and give the clients more of an easier journey to sort of instruct us and go through the sort of conveyancing concierge and arrange sort of services outside of conveyancing like insurance, removal, stuff like that. So I can tell you all about that if you're interested another time.
Oh, excellent, Stu. Yeah, and what's the product called?
Moving Me.
Well, we definitely a separate chat. But congratulations, Stu. I was really delighted to see that all of that hard work, paid off. So things that conveyancers need to be to be keeping an eye on, Stu. We've had a lot of news, sort of conveyancing news and things happening over the last sort of few months since we last did a news article. So what's caught your eye?
Yeah, I suppose the renters reform bill's one, isn't it? It's certainly something that's been in the headlines now for a while. Obviously, it's not going away, and most commentators are sort of thinking it's going to be hitting us again at the end of the year, isn't it?
Yeah, the good old renters' rights bill. Yeah, theoretically, maybe on the statute books as soon as the end of the year. I mean, clearly the issue for sort of frontline conveyancers, I think, is obviously the impact on buy-to-let
Absolutely.
transactions, as I think you and I have mentioned before. So really, it's just one to watch. I mean, the government seems very committed to it, so we'll see where that brings us. But to move on, Stu, the running soar of the Property Information Form and the Law Society rumbles on.
It certainly
Uh,
does.
the Law Society saw fit to do an announcement on this during towards the end of the stamp duty land tax melee. So great timing there from them. But basically, the as you'll remember, Stu, we had the Property Information Form Edition 4, which has been with us for yonks. During 2024, last year, the Law Society put out the fifth edition, which sort of picked up all of the material information guidance from trading standards for estate agents, massive kickback from conveyancers, and essentially the Law Society said towards the end of last year, well, conveyancing firms could choose to use either the existing Property Information Form
Yeah.
fourth edition or the fifth edition. But what they've now announced is that the sixth edition is in development following a consultation that they had. And apparently that's going to be available from the Law Society's licensed suppliers, Stu, from October.
Yeah,
So, it's a wait and see. I mean, clearly that sort of suggests that the fifth edition is now dead in the water. I think that's really a tacit admission by the Law Society.
absolutely.
That terrible fifth edition, which personally I always thought opened sellers up to significant
Of
misrepresentation
course.
claims and risks. Um, so the Law Society said that they're sort of, working with the profession, that they're going to be trialing the sixth edition, which is going to sort of be update the fourth edition, but they are also intending to have alongside that an optional material information form. They're going to decide what they're going to call it as the year goes on. So and CQS firms are going to have to use the sixth edition from next March 2026. That's the time frame at the moment. But of course,
Yeah,
Stu, it's just a wait and see. I mean, we've been here before, haven't we? The Law Society trying to mandate that
yeah.
forms will be used and then having to backpedal. But
Let's just hope they took note of the uproar that was caused last time.
yeah, absolutely. I mean, are you presumably continuing to use the fourth edition, Stu?
Yeah, we are. I think it's a complete 50-50 split now across the profession, I would say. And we've seen a hell of a lot, a lot of them in this sort of stamp duty period. So, I think people are getting a bit bored of it now, if anything. It's we've been talking about it it's gonna, well, by the time the next
A
edition
year.
comes in, it's gonna be, yeah, years.
Yeah, I mean, I think
So,
the problem is though with all of these things, and everybody has got very sort of swept up in the moment with the volume of work that the stamp duty land tax deadline produced. But of course, slightly, I suppose, from the outside looking in, which I guess is where I am now, um, I think it has gone off conveyancers' radar, but it's going to be back on when a misrepresentation claim hits the
absolutely.
courts. And
Yeah.
that's the point, isn't it? So what I think firms ought to be doing is, given that the Law Society appears to have tacitly suggested that the fifth edition is now really null and void, they're not, they're not mandating its use at any point. They are producing a further edition later in the year. So firms, perhaps from a risk management point of view, may want to consider and reflect on the forms that they're using now, and decide whether or not they want to go back to the fourth edition, or continue to use the fifth until the sixth is with us. But anyway, um, so moving on, Stu, what have you
Yeah,
got
well, the
next on the
land
list?
registry. Yeah, so from the 2nd of December, they've changed their address.
Yeah.
So it might not seem particularly big news in the grand scheme of things, but of course, we've just got to be a bit careful, especially when we're sending those original title deeds. We certainly don't want those going walking off to the wrong offices, do we?
No, absolutely. I mean, conveyancers should just go to the land registry website to check on the addresses. We reported, I think, in our last sort of quarterly news bulletin, didn't we, Stu, that the land registry have gone back now to wanting original deeds for first registrations, as you've said, and that presents a risk for conveyancers. They're going to have to put the damn things in the post, so it is really, really important that conveyancers are sending them to the right place. Because the minute those deeds get lost, that's potentially,
Nightmare.
a complaint and a problem. So moving on, Stu, conveyancers, and I think a lot of what we're talking about at the moment in this news bulletin is actually, things to look out for. But the
Yeah.
government has been sort of, had quite a lot of sort of legal aspects in its crosshairs, and particularly the sort of home moving process. There's been the suggestions of digitising the process, and we of course talked about that to Mike Harlow from the Land Reg earlier in the year. But the government's appetite for common hold, as what they describe as the default form of
Yes.
tenure, continues apace, and I think that conveyancers should go and read the white paper, which is now out. It sets out the description of the reforms and what the government thinks need to be changes to the current common hold system, and apparently there's going to be allegedly at least a bill in the second half of this year. But what the government is saying at least is, and these are the government's words, not mine, the framework is going to be supplemented by a ban on the sale of new
Mm.
leasehold flats. So they want common hold to be the default form of tenure. Something that absolutely sends a shiver down my spine, Stu, is the suggestion by the government that they are, and I quote, still working on an easier way to convert existing leaseholds to common hold. Mm, I just have very significant reservations about that. I think that could be very, very destabilizing for the market.
Well, it's going to be very much watch this space, isn't it? But the one thing on common hold that does seem to be the government's appetite to actually bring it in. They
Yeah,
do seem very keen, and like we've sort of expressed before, the word in default tenure is a bit concerning, isn't it?
yeah,
They're not just going to
absolutely.
slip it in the back door, are they?
No.
So yeah, so it is a bit worrying, and I think bringing another tenure in actually in the world of conveyancing, it's going to be something absolutely huge, isn't it?
It
So
is. I mean, and ultimately, of course, the lender's appetite is going to I think, dictate the market.
yeah.
But I mean, for anybody that's interested, we've actually done another sort of YouTube chat on but broader common hold issues fairly recently. And actually, if anybody wants to subscribe to Conveyancing Matters to get your CPD, your monthly CPD, £40 for an individual for a year and £150 for a firm for a year. Lots of videos are available now, and of course, we've done one, haven't we, Stu, on sort of the current common
Yeah,
hold framework to sort of try and bring it back into people's minds. So we've got
absolutely.
resources available for people on common hold, but it's always that balance, isn't it, between, well, we don't want to talk too much about something that might never happen, but the converse is that the government seems quite committed to it. So
Absolutely,
we'll see.
definitely, yeah, absolutely.
And speaking of sort of government changes, Stu,
Yeah,
where do you
yeah.
want to go?
So yeah, the Leasehold and Freehold Reform Act, 2024. Most of it's still not in force yet, but one thing to note is the 2-year rule regarding enfranchisement, which has been removed from January this year.
Yeah, so theoretically, it's going to make it easier for tenants to sort
To
of
buy.
enfranchise. Again, really sort of, perhaps sort of harking back to the earlier comments on common hold. I mean, I think the problem with a lot of the Freehold and Leasehold Reform Act, it's going to be tied up for quite a long time. The Leasehold Knowledge Partnership, which actually is a very good resource, by the way, has reported which isn't going to come as a surprise to lots of us, Stu, that judicial review proceedings relating to that 2024 Act have already started. A number of freeholders have been granted leave to apply for judicial review, basically to challenge the threat to their income that they say is being brought about by the Act. And in particular, and as I say, this is reported by the Leasehold Knowledge Partnership. And I quote from them: the High Court held that the freeholders had an arguable case that the and that provisions in the Leasehold and Freehold Reform Act relating to cap on ground rents, payment of marriage value, and removal of freeholders' rights to recover reasonable legal and valuation fees breached landlords' private property rights under the Human Rights Act. That, I think, Stu, bottom line, is going to run and run. So the hearing apparently isn't set to be heard until the end of July. So I think what that tells us is that these sections of the Act are unlikely to be coming into force anytime soon, and the government's going to have a real job on its hands to change sort of existing frameworks relating to leases. So one has to say, therefore, whether the government is going to be successful in actually jettisoning most of leasehold as a form of tenure and replacing it with common hold, therefore, is perhaps also quite questionable. But there we go, another one to watch. But something you wanted to mention, Stu, that's much closer to your heart, really, and that of many conveyancing, law firm managers and senior partners.
Well, again, this year we've got a number of sort of topics in the news, and one which definitely isn't going to be going away is actually the holding of client money. So the SRA are recently about to launch a consultation on the, what should we say, sensitive topic of solicitors holding client money. This definitely isn't going away, is it? I think the questions posed by the SRA are: should we be looking at ways to reduce the client money held by solicitors? What controls, checks, and balances are appropriate? And should payments from professionals be calculated and payments from the fund to reimburse consumers be allocated? So, yeah.
Yeah, I mean, for me, this really is a closing the door after the horse has bolted. I mean, the SRA actually has, the last few days come under absolutely stinging attack from the Legal Services Board, the overarching regulator, as indeed, to be fair, has the Bar Standards Board. But the SRA regulates, far more lawyers than any of the other regulators put together, the rest of the regulators put together. And I can't help thinking this focus on should law firms be able to hold client money actually stems from the Axiom Ince debacle, where, of course, £64 million, that's £64 million, was sort of went missing from client account. And basically, pretty much, I think everybody is of the view that, including, I hasten to add, the Legal Services Board, that the SRA was asleep at the wheel. And of course, this is a big issue for the likes of me because, my practicing certificate fee went up by 90 quid. Every SRA regulated firm, Stu, had to pay in excess of £2,000 last year, effectively to top up the hole in the compensation fund. So I think this has led the SRA to sort of really, in my view, come out on the attack and say, oh, look, money went missing. Should solicitors be able to hold money? Rather than, was the oversight of this particular organisation a failure of regulation? I think they're just trying to put the spotlight elsewhere. So I know that the CLC has sort of been looking into third-party managed accounts and so on and so forth. So it's certainly a hot topic for law firms, law firm managers. The SRA consultation, I think, has now closed, but whenever anybody in a law firm gets the opportunity to respond on this, they should, because I don't think there's an enormous amount of evidence that third-party managed accounts would necessarily be, significantly better in many ways, and certainly would, I think, increase the costs to clients.
Absolutely.
But equally, as I say, the SRA has come under very, very swinging attack in the last few days. The main man is going. He said he's retiring. So maybe the combination of those things will actually mean that that the SRA's got a bit less clout than perhaps it has had. But look out for that, because I think, look for conveyancers, law firms not holding client account money would be very, very significant.
Absolutely. Another massive cultural change.
Yeah, absolutely. Now, the SRA has said, and I do agree with this, they have said that, look, law firms shouldn't really be sort of massively benefiting in terms of interest on money held on client account. And they did some research and actually found that quite a lot of law firms were effectively reliant on that interest to sort of stay afloat. And I think that's a separate point. You don't need to throw the baby out with the bathwater. You just need to make sure that interest on money held in client account is dealt with appropriately. But that's a very different proposition to saying, well, in that case, we won't let you hold any money at all.
At all, yeah.
Anyway, I did want to mention, moving on, just to practitioners, really, I think it's always worthy of note when the Land Registry produces a new practice guide. And they produced a new one on the 10th of March, actually, Practice Guide 83. And it's on alterations to the register. Now, it's one of those things that we actually, probably conveyancers actually try and, they alter the register more than they think. If there's, and if you get your registration back and a name's been spelt incorrectly, you'll probably try and get the registry to update it very quickly under what used to be called the slip rule. And if you respond to the Land Registry quickly and say, well, there's a typo here or a problem, can you put it right? They often will. And it's going to be much easier to do that immediately your registration's concluded, rather than in 5 years' time when the registered proprietor wants to sell. But the thing is about so we're always used to dealing with alterations, but the guide gives information about how and the purposes for which the land register can be altered, either by the court or the land registry itself. It gives information for conveyancers, well, everybody, but for conveyancers particularly, about how to make the application for alteration, and explains the limitations on the land reg on their ability to alter the register where the alteration amounts to rectification. So, it's not something that conveyancers will need to consult on every day, but there are controversial points in there, because alterations of mistakes made by the land registry are also addressed, and they do happen. So it's probably just an awareness raising thing for conveyancers to know that it's there, and if they need a more serious alteration rather than just a typo, then they should go to that guide before they do anything, I would suggest. So what's next for you, Stu?
So the legal ombudsman, and again, going back to the SDLT, we thought we'd heard the last of it. Well,
Yeah.
hopefully we have. But just in case you have got clients that are complaining where maybe deadlines have been missed, the legal ombudsman have released an article aimed to help law firms deal with those situations. So that's definitely going to be worth having a look.
Yeah, I mean, I thought it was really interesting that the legal ombudsman was, putting out content for law firms about such a specific thing. They obviously perceive
Yeah,
that people missing the stamp duty land tax deadline are going to complain. And I can't believe there isn't a firm in the country, Stu, that hasn't been saying to clients and putting on its website since the end of
yeah,
last year, if not earlier, we can't guarantee to meet the deadline. But Leo
of course.
clearly thinks that, complaints will be forthcoming, even though there would be so many things outside the conveyancers control. But it is a resource that Leo has put out. And of course, all firms, whether SRA or CLC, should have a look at it, because if you do have a complaint that gets to Leo, well, particularly about the SDLT deadline, well, it would be good for the firm to show that they'd sort of read and followed Leo's
Of course.
guidance that
Yeah,
they've
of
sort of
course.
preemptively put out. So
Yeah, and don't forget, law firms may have done everything they possibly can. It doesn't stop necessarily the complaint, does it?
no, of course it doesn't. I wanted to move on, Stu, just really to mention in passing the good old EWS1 certificate, the certificates indicating the type of cladding that might have been used on a property and fire risk specifically. So nothing to do with the Building Safety Act, actually. Now, I've been saying to on my courses and so on for a very long time, Stu, that there are fraudulent and have been fraudulent EWS1 certificates
Yeah,
out there. I mean, they're so valuable that, of course, they're going to be
of
fraudulent ones.
course.
And there are different requirements depending on the type of work that might be needed, and the different requirements in terms of who signed off that certificate, depending on the type of work needed. And I've been suggesting for a long time that if a firm is presented with an EWS1 certificate, they should actually be carefully checking who has signed it off, what organisation they're with, is the person that signed it off qualified to sign it off, and has that organisation got the appropriate indemnity insurance? All sounds like a complete faff, but I mean, the chickens have come home to roost a bit, Stu,
Yeah,
and I just wanted to mention it in passing. It's even got comments been made on in Parliament, but there's basically been many certificates signed off by a bloke called Adam Kiziak, Kiziak, and his firm Try Fire. And as I say, he's been sanctioned for, and I quote, failing to hold adequate professional indemnity insurance, having undisclosed prohibitive exclusions, failing to meet professional competency standards, and breaching the ethics code regarding accuracy due diligence. And major lenders, including Nationwide, NatWest, and HSBC, are refusing his property
yeah.
assessments, are refusing his EWS1 assessments. So the RICS has sort of stepped in and said, well, if anybody does see an EWS1 certificate signed by Adam Kiziak or Trifire, they are recommended to seek lender and client instructions as to how to proceed. A really difficult one, but again, conveyancers don't want to be sort of picking up the tab in the event of a problem. So I thought that was worth
It is a
alerting
really
people
difficult
to.
one. So again, it's something else now we've got to do, check and eventually worry about. But I think if you do see that name, you've got to report it to the lender straight away and seek their instructions.
Yeah, absolutely.
Don't
And
do anything
frankly,
else.
and as we know, freeholders get these EWS1 certificates. They're supposed to be valid for 5 years. There's a shortage of specialists to provide
Yeah,
these certificates. If that hasn't been, if it's not acceptable, then it's likely that another one is going to be needed, of course. So the lender's probably not going to proceed with one, signed off by him. Hasn't got appropriate indemnity insurance place in any case. So who would want it? Um, and of course, I think, that the issue for leaseholders, of course, is the stress of those transactions being held up. But of course, presumably Mr. Kiziak and Trifire have already been paid handsomely to produce those, those certificates that aren't any good. So the good old leaseholders, bless them, are probably going to have to shell out again
yeah, yeah.
for ones to enable them to effectively to move. So I think that's the first thing conveyancers should be doing. If you see an EWS1 certificate, make the checks I've just mentioned, but if it's signed off by Adam Kiziak or Trifire, you know,
Got a problem.
you've
Yeah.
got a problem. You've got a problem. And speaking of problems, Stu, something that hit the headlines, moths.
Yeah, well, we might not all be transacting on properties to the value of sort of 32.5 million. But there is some there is an article in the press where you can actually read all about problems with moths. Who would have thought it? Okay. You know, look, it's all about misrepresentation, what the sellers have said, and in this particular case, it does look like the sellers were telling some porky pies. And of
Yeah.
course, good old misrepresentations come in and help the client in this respect. So it's well worth a read.
Yeah, absolutely. As you say, it's another world in terms of property values for most of us, but does just come down to, and this is what's interesting to me, is that it's come down to the very basic point of did the seller, fill in the PIF and
Yeah,
answer the inquiries properly? And the bottom line was, big property. I think he'd, dare I say, had some renovations and stuff done, and had gone down the sort of, the eco route
yeah,
and put insulation in that potentially had moths in it. The point was he knew he'd taken some steps. He tried to say
yeah,
he hadn't. The buyers didn't find out until they moved in. Lo and behold, they took an action for misrep and were successful. Of course, he's now been ordered to pay them 32.5 million back, but he hasn't got it. So I think this is going to run and run.
absolutely.
But as you say, Stu, the bottom line, misrepresentation. And frankly, it doesn't matter whether it's a £30,000 flat or whether it's a £32.5 million mansion.
It doesn't.
The seller has got to answer the inquiries correctly. And of course,
Absolutely.
this ties in with the things we've been talking about earlier. It ties in with material information. It ties
Sure
in with the
does.
property information
Yeah.
form. It all ties in.
It's the foundation of conveyancing, isn't it?
It is.
Relying on what a seller tells you. So yeah.
Absolutely, absolutely. And the sort of last point to mention today, Stu, we've covered quite a lot of news, but there's been quite a lot to say.
Yeah. I mean, there's the CLC are doing a consultation on CPD. They've developed a new ongoing compliance code, which incorporates the high level principles and feedback that they've received. It's intended to replace the current CPD code and CPD frameworks. I think the deadline for comments on that one is the 11th of April. So you can go to the CLC's website to look at that further.
Yeah, it's the ongoing competence code. So CPD consultation for CLC firms if you're interested. So Stu, well, thanks for that. I mean, there was a lot to say, wasn't there? But and I thought it was worth us sort of chatting about quite a few things because I suspect that conveyancers are now really only lifting their heads from, as I say, the stresses of the last few months. So it was probably worth in this spring news bulletin just mentioning.
Well, I doubt anybody's had time to look at the news over the last month, so hopefully it's a bit of a refresher for everyone.
Absolutely. Well, thanks ever so much, Stu. And if I don't see you before, I will see you at our celebrating the end of the SDLT No Holiday event on the 15th of May. Take care.
Absolutely. Looking forward to it.
Bye.